afternoon, everybody. My name is Peter Ashford. We're having quite a few people still join us, so we'll leave it another minute or so as the numbers climb on the dreaded participant list. But bear with us for another minute or so. Thank you. Good afternoon, everybody. For those of you who don't know me, my name's written underneath my pretty face. My name's Peter Ashford. Good afternoon and welcome to this panel discussion on the issues raised in this year's Moot problem. The good thing about webinars, there has to be some good thing about webinars, and perhaps the only good thing is that I'm relieved of the obligation to give the usual warnings about fire escapes, where the toilets are, and to put your phones on silent or turn them off, because if they ring, I can't hear them and I really don't care. So that's the good thing about webinars. Without further ado, may I introduce our panel for this afternoon's discussion. On, I think, my left, Marion Smith, QC, who's the very busy silk in her practice at the bar, and is also Deputy Chair of the Board of Trustees of the Chartered Institute of Arbitrators and a Vice Chair of the International Committee of the Bar Council. She is visiting Senior Lecturer in the School of International Arbitration at Queen Mary, and she's a contributor to the Global Arbitration Review Guide to Construction Arbitration, and as I've said, a practicing silk at 39 Essex. To my right, Sir Nigel Tare, after a busy practice at the bar from Quadrant Chambers, Sir Nigel was appointed to the High Court as a judge from 2006 until his retirement in September 2020. During his time as a judge, he was in charge of the Commercial Court and the Admiralty Judge. He's now available and accepting many appointments as arbitrator. Below to my left is Professor Denny Morales, Professor of Law and attorney at the Paris Bar, specializing in commercial and arbitration law. Denis regularly takes part in domestic and international arbitrations, both as arbitrator and as counsel. He also acts as an expert on French law and EU law before foreign courts. Below my left, to my right, is Robert Temmink, QC. Robert has a wide-ranging and international practice in commercial and chancery law, both as counsel and arbitrator. He's additionally called to the bars of the East Caribbean for his holidays and also Northern Ireland. He's a registered advocate at the Abu Dhabi Global Market Court and the Dubai International Financial Centre Courts. He's a foreign legal consultant in the state of New York. In the usual way, you may submit questions anytime you wish during the Q&A function. We will have a look at those, and if we have time, we will try and get the panel to answer at least some of those. Some have been put in advance. I have those, and we'll try and take those as we go along. The webinar is being recorded, so I'm not sure whether that records your Q&A or not. There we go. You're on notice. At the end of the debate, we're going to take a short comfort break, and then please join us for virtual networking, for which you have a separate Zoom invite in the reminders that you would have had for today. It's at the bottom of that reminder. It's also going to be posted into the chunk, so you can copy and paste from there. So when we finish after 5 minutes or so, when we've had a comfort break, got a glass of wine or whatever, we're going to regroup in there. We'll then randomly allocate people to breakout rooms, and you may or may not get the person you want to speak to. It'd be a bit like speed dating, but worse. Without more ado, then, we're going to move on to the meat of what we've got today. The moot problem this year is very topically about vaccines for something called COVID, which you may have heard of in your day practice, and whether competing businesses have the right to manufacture that vaccine. The two procedural points that arise are whether or not a third party, we'll call them, can point to the arbiter, and if so, what considerations the tribunal should have in mind. And secondly, one party wants and the other party opposes a virtual or remote hearing, saying that there should be an in-person hearing, which would delay the proceedings, we're told, on the problem details by about 4 months. And again, is there a right to an in-person hearing? And if so, and if not, if it's a matter for the tribunal's discretion, what sort of factors should the tribunal have in mind? We're not going to try and answer the moot problem. That's not the function of these discussions. What we are going to do is simply talk around some of the legal issues that arise both under English law, which most of us profess to know something about, but we've also got Professor Denis Morales to tell us a little bit about French and EU and perhaps some other civil laws as well. Because as we all know, or those who do know, the moot is set in a hypothetical neither common law nor civil law country, so all arguments are perfectly fair. So moving on to the first topic of joinder, and I'm going to use joinder as a broad church phrase to encompass all sorts of formal joinder, consolidation, vouching in, and all sorts of other things. It undoubtedly gives rise to issues of efficiency, and avoiding inconsistent decisions, but equally it has problems associated with it, particularly around confidentiality and elsewhere. But Sir Nigel, can I come to you first from your time on the bench when you would have seen many, what we used to call in the good old days third-party proceedings, but now it's something called Part 20, I'm given to understand, that there are perceived benefits and disadvantages of joinder and consolidation. What's been your experience of those sorts of issues, and any particular examples that you've come across?
Thank you very much, Peter. Well, joinder is an everyday event in court. For example, it occurs where the same claim is brought against more than one defendant, or where one of the parties, a defendant, has a right to an indemnity from another person. And as you've just mentioned, there are three very obvious advantages to joinder. First, there are likely to be savings in the overall cost of the litigation if there is one action with several parties rather than several separate actions. Secondly, joinder avoids the risk of inconsistent judgments, something very obviously to be avoided, and a risk which others have described as a judicial nightmare. And thirdly, the court is able to decide the issues with the benefit of all of the relevant evidence. Consolidation is very similar. It occurs where two or more existing actions are in effect joined together. The advantages are the same. Now, those advantages which I've mentioned are matters which are attractive to the court. And when they clearly exist, the court will exercise its discretion to permit joinder or consolidation, or, which is little difference in substance, ordering two or more cases to be managed and tried at the same time. But what is perceived as a benefit by the court may not be so regarded by all of the parties. For example, whilst the overall costs may be reduced, it does not follow that the costs of an individual party will be reduced. A claim against one defendant may be straightforward, whilst a claim against another defendant may be more difficult and take longer to try, so that the effect of joinder or consolidation may increase the first defendant's costs because the trial is longer. Also, a defendant may prefer the case to be tried only on the evidence which is of immediate relevance to him. So the advantages of joinder may be regarded as macro advantages in the interests of justice, rather than as advantages benefiting all parties equally. You asked, Peter, for an example of joinder. As I've said, it's an everyday occurrence, but there is one unusual example I will mention, because it involved an arbitration application and a High Court action for damages. And unusually, they were tried together with the evidence common to both. There was an arbitration between A and B. B contended that A was not a party to the contract, which contained the arbitration clause, so that the tribunal was said to have no jurisdiction in respect of A's claim over B. It was said that C was party to the contract. The tribunal ruled that A was party, C was not, and so the tribunal had jurisdiction to hear A's claim against B. B challenged that decision pursuant to Section 67 of the Arbitration Act by issuing an application to the High Court. And that meant that there had to be a retrial of the question who was party to the contract. At the same time, C issued High Court proceedings seeking a declaration that C was party to the contract and that A was not. Thus, the same issue arose in the arbitration application and in the High Court action. I ordered that both be heard together. That made obvious sense because evidence from A, B, and C could be heard in the one set of proceedings, and there was no risk of inconsistent decisions. Perhaps a risk of a wrong decision, but not at any rate of inconsistent decisions. That is perhaps an unusual example, but it is one which demonstrates, I think, the advantages of trying claims together. I hope that assists, Peter. I think you're on mute, Peter.
It was going to happen. It was inevitable. But I thought if I do it first, it would then be all right for everybody else to do it later.
Thank you.
Yeah, thank you. Marion, consent is always fundamental in these things. How does joinder fit into the concept of consent?
Arbitration, autonomy, consensual, apple pie and motherhood. We can't imagine any other structure. You would have thought by now that everybody builds into their contracts where they're dealing in supply chains or they have an economic transaction involving a large number of people, a form of joinder, consolidation, contractual provision, because the problems that joinder causes in the consensual dispute resolution field are well known. I'll list those out in a moment, and you can avoid all of it if you agree it up front. And I'd be really interested to know if anyone is seeing a trend. By the way, you don't have to put a question in the Q&A box, you can put an observation in, an expression that we all love as arbitrators. I invite observations. put it in. Let us know. Are you seeing now a recognition that the dispute resolution clause has to be more flexible? Very interested to hear. Or are in fact they remaining true to form? They are midnight clauses. Nobody thinks about it. And joinder becomes the issue as soon as you actually have the dispute. Now, the problems are well known. Some of them are not exclusive to the arbitration field. Everything that Sir Nigel listed out applies. I always find that a client in an arbitration greets any announcement to the effect that consolidation will save money with frank disbelief. They have found that the more lawyers there are involved on any issue, the greater the cost. It never results in a lowering of the cost. But the very specific problems you have in arbitration are, of course, the formation of the tribunal. If you take as one of the key advantages of arbitration the fact that you can participate in the selection, I'm not going to go to say that you have your party nominated arbitrator, but you at least have participated in the formation and you have had the right to select. Joinder, bringing somebody in, not party to the original arbitration agreement, creates a tension. What rights do they have to select? How are you going to build that consent to the panel formation from the beginning? Confidentiality. I mean, the ICC in their guidance say they can't even tell a third party who approaches, like something out of Jane Eyre in The Marriage to Mr. Rochester, and announces, I want to intervene. They say, I can't even tell that third party that there's an arbitration. So you've got the fundamental issues of confidentiality and privilege. And you've also then got to think about generally the interplay with the institution, that sordid topic of contribution to the arbitrator's fees and the payment on account. So all in all, plus ultimately the problem of enforceability. If a court faced with the enforcement of an arbitration award thinks that the consolidation or joinder was inappropriate, then there would be grounds to challenge that award, for example, along the lines that the arbitrators have made a decision outside the ambit of the arbitration agreement. So all of those factors make it a very sensitive topic in the context of arbitration, and it's why, of course, the institutions have sought to, and increasingly are seeking to rise to the challenge. And no one so far has said that they know of a contract which provides for it or an increased trend. Anyone know of any data? Are people consolidating and joining in arbitrations more widely? Are you finding that, Peter?
Well, now I'm off mute, Marion. I can answer your question, but I think you are, and I am in my own small way as arbitrator also seeing that. And Robert may recall this one as well, because I think he was involved in this case, that we had a joinder issue in one of my really big first arbitration, and the parent company was joined in only because it had lots of money, and there was going to be some esoteric argument about group of companies and things, which Denny will know lots about, but so far as English law is concerned, is a nonsense argument. And we were working really hard in the case, doing all the evidence. And the legal team for the parent were quite literally playing hangman during the hearing, because that's about as busy as they were. So from their point of view, they sat through a very long and dull hearing when actually the disposition of the could they be joined point took about half an hour right at the end. And they were playing hangman throughout the whole thing, and perhaps worse. Robert may have had a better view than I did, but being taller.
Extremely brief, wasn't it?
It was extremely brief, yes.
But no data.
But thank you, Marion. That's very helpful, and perhaps people may comment a bit more as we go on. Denis, can I turn to you now about where will consent, where and how will consent likely be manifested? Where do we find the consent that people have given for joinder?
Thank you, Peter. Well, I will try to present this in a clear way, because all those issues are very complicated, I find, and a bit. Sometimes there is some confusion. But I think to make this clear, we can say that consent can be expressed at the time when the joinder or the consolidation is asked for, or it can be expressed beforehand. And I will first address first the circumstance when consent is given when the joinder or the consolidation is asked. It's not the chronological order, but it is the easiest situation. So if you imagine you have an arbitration, an ongoing arbitration, and a third party wants to intervene, or one of the parties wants a third party to be joined, or you have two arbitrations, two ongoing arbitrations, and the parties want all those arbitrations to be consolidated. Well, if all the parties agree, there should be no problem, normally. And their consent can even be implicit, since under all legislations there is a principle derived from estoppel. When a party during arbitration does not object to an irregularity, this party is presumed to have waived the right to, or really waives the right to invoke this irregularity if the award is challenged. There is section 73 in the English Arbitration Act, and the same provisions in almost all legislations. But of course, it would be better to have their consent expressed in writing. You can maybe write a new terms of reference, or you can have the parties sign an addendum to the terms of reference, or even letters by which the consent to the consolidation or the joinder. Now, we always think about the consent of the parties, but we should also think about the consent of the arbitrators. And I find this the arbitrator's consent is not addressed a lot, but it is important because arbitration is based, as Marion said, about consent, but also the consent of the arbitrator. There is a kind of contract between the arbitrators and the parties. So imagine, if we think about a joinder, we have arbitrators, or one arbitrator, who have accepted to judge a particular dispute between A and B. And now this arbitrator or the arbitrators are asked to judge another dispute between B and C. Of course, normally there will be a connection between those disputes, but it's not, it's something more. So it means more work. And if we think, and also there may be a conflict of interest which did not exist. So how do you solve this? Well, about the additional work, I think the solution is very simple. Arbitrators will ask maybe for more fees. About the conflict of interest, remember, the idea was all the parties agreed. So I think if all the parties agreed, they can dismiss an arbitrator. If the parties agree, they can put an end to the mission of any arbitrator. So that would be the solution if there is a conflict of interest. But it may be necessary to pay the arbitrator part of the fees for the work that he or she has already done. Now, if we imagine the consolidation of two ongoing arbitrations, we will have, normally we will have, if the arbitrators in both arbitrations are not the same, it means that one of the arbitral tribunal will have to judge another dispute, and the other arbitrators will be dismissed. So again, the parties, if they agree, can dismiss one of the arbitrators of one of the panels, no problem. The only issue may be how much they will be paid for the work already done. And as to the arbitrators who will have to judge the whole dispute, they have to accept it, I think, but they will probably ask to be paid more. Now there is also the consent of the arbitration center if we are thinking about administered arbitration. Well, I propose this, but maybe someone will disagree. If the arbitration rules of the center provides for consolidations and joinders, well, you have to follow the rules. So if the conditions are met, it's possible. If they are not met, it's not possible. Now, if the rules are silent, and there are rules which are silent, I propose to consider that it means the center does not object to the consolidation as long as the parties and the arbitrators agree to it, as I've said. But I understand maybe someone may disagree with this. Now, consent given beforehand, how and when? I think it can be given through the arbitration rules. This is maybe the most obvious situation. And it is the situation with the moot problem this year. By adhering to the Swiss rules, the parties have probably accepted the principle of a joinder or a consolidation. I think if this is the case, it's not very complex. Parties can be compelled to accept the joinder once the arbitration has, or one of the arbitrations has begun, since they have accepted the right of the center or the power of the center to order a joinder or consolidation. Consent can also be given through the legislation. So it may not be exactly consent, but we know that some legislations provide for joinders. For instance, the Dutch Civil Code of Civil Procedure, it is a very well-known example. So if you arbitrate in the Netherlands, it means that we can present it like this. It means that you have accepted Article 1046 and Article 1045, 1045A, and then it means that the arbitration center can order a consolidation or a joinder or a judge. But if it is a judge, both arbitrations that are consolidated must be seated in the Netherlands. And it is quite logical, it's very, very consistent, because the idea, I think, or very obviously, of the people who drafted this provision is that people arbitrating outside the Netherlands either have consented to consolidations and joinders through arbitration rules, or they have not. So, on the other hand, people who arbitrate in the Netherlands have accepted the principle of a joinder. Now, last possibility, and I will not be longer, don't worry, Peter. Last possibility, the parties may agree to joinders and consolidations through arbitration clauses. You can imagine an arbitration clause saying that, for instance, if there is a dispute between the parties to the contract and the parties to another contract, which is referred to, both arbitrations can be consolidated or parties to the other contract can be joined, so something like that. You can also maybe say that in a multi-party contract, there is an implicit consent to consolidations and joinders. Imagine you have a contract between A, B, C, and D. An arbitration begins between A and B. You can argue that by signing this unique arbitration clause, C and D have accepted to be joined. There is an interesting case, a judgment by the Court of Appeal of Paris, dating back to 2019. I can give the reference if somebody is interested. In this case, the Court of Appeal said that it was not possible for a French judge to order the consolidation of several arbitrations based on several arbitral clauses because obviously the party's intent was not those arbitrations to be consolidated if you looked at the clauses. But if you think about it, it means that on the contrary, if you can detect in the clauses a consent, or if the consent is explicit, then a French judge could order a consolidation, which is interesting because in French law, there is no provision about consolidations by judges or arbitration centers. Thank you.
Denis, thank you very much. A lot of stuff there, which people, you invited people to disagree. No one's leapt in with a disagreement, but I guess Marianne's itchy, I can see her.
Maybe, yeah, I had the feeling she may disagree.
I think that's all fairly orthodox. Actually, from an English perspective, I don't think there's too much there. It's the it's the hard cases where you're going to get perhaps linked contracts rather than perhaps A, B, C, and D all contracting together, but subcontracts, or subcontracts might be easier, but linked contracts where it's not so obvious, perhaps in a supply chain where A and B don't necessarily, or A doesn't know who C is, and whether if they've got similar agreements, there is something there. But that brings us on to perhaps inferred consent. So Nigel, can I come back to you on inferred consent? We know that the Supreme Court's had a lot to say over inferred or implied consent in the context of disclosure by arbitrators in Halliburton and Chubb. Is there scope for taking the same sort of inferred or implied consent as far as joinder?
Yes, thank you, Peter. Consent in English law may, of course, be express or implied, and there's no reason in principle why consent to joinder cannot also be implied. The Supreme Court in Halliburton considered the question of implied consent in the context of an arbitrator disclosing what would otherwise be confidential matters in an arbitration between A and B, when that was necessary to enable proper disclosure to be given of matters which might be relevant to an assessment of his impartiality in an arbitration between B and C. The Supreme Court held that such consent to such disclosure could be implied, where, for example, the institutional rules governing the arbitration required such disclosure to be given, or where there was a practice in a particular field of arbitration of making such disclosures, for example, in commodity or shipping disputes, where there are string contracts, and so multiple arbitrations can be expected concerning the same event. That approach, which might perhaps be described as a generous approach, suggests that in an appropriate case, there should be no, at any rate, conceptual difficulty about implying consent to joinder. But given the central role of party autonomy in arbitration, it is likely, it seems to me, that tribunals will be wary of implying consent unless there really are cogent reasons for finding such consent. Otherwise, there is a risk that a party's confidence in the integrity of the tribunal might be damaged. So in what circumstances might consent be implied? Consent might be implied from a party's actions or statements after another party has suggested that a third party be joined. But I would have thought that before consent could be implied in such a context, it would have to be shown that the actions or statements of the party alleged to have consented only made sense, that they could only be explained on the basis that there had indeed been such consent. There is also the possibility that consent might be implied in an arbitration agreement. Some contracts may have multiple parties, as earlier suggested by Denis. If the contract contains an arbitration clause and does not deal specifically with the question of joinder of claims, one can see a substantial argument that it is an implied term of the agreement that the parties agree to joinder, where there are several claims under the one contract. Such implied consent could be said to be necessary to make the particular arbitration agreement work. So there is scope, I think, for implied consent. But as I said earlier, I would expect it to be found only in very clear cases.
So Nigel, thank you. Perhaps if we had a little more time, we could discuss the actual position in the moot of two separate contracts, but each incorporating the same rules that give a broad discretion to the tribunal about whether or not joinder is permissible. There would be an argument, at least, presumably, that by agreeing to rules that permit joinder, there would be, if both contracts have got that same permission, they could both be joined, but we need a bit more time to delve into that in greater detail. But it will be, Robert, won't it, a question of assessing the legal environment in which that joinder is agreed to, and what law governs the ability to have a joinder.
Yes, I mean, that's surprisingly thorny. I always think that implied consent is really the way for judges and arbitrators to do what they think is right in a case. You just say, well, of course we can imply it. What are the questions? Is it the law of the arbitration agreement? Is it the law of the seat, the law of the substantive law of the contract? Or can we get past it on consent either express or implied? Well, in England, at least, and in the little review that I've done of helpful authorities, there isn't much help. The Supreme Court in England in October 2020 found that the law governing arbitration agreements had to be determined by applying the common law rules for determining the law governing contractual relations, which would be the law expressly or implied chosen by the parties. Or if there wasn't such a choice, then the law with which the arbitration agreement was most closely connected. And that, of course, is the refuge of arbitrators under some institutional arbitrations, because there's, I think it's Article 17 in the Icc Rules, which gives tribunals that express power to choose to apply that law. So the proper approach, I think, for determining whether there's been a choice of law was to apply the law of the seat. So English law in an arbitration sitting in London. The court looks at the contract as a whole and applies ordinary and, I think, what are now well-known English rules of contractual interpretation, going all the way back to the Investors' Compensation Scheme case, but ending up with Arnold and Britton and Rainy Sky and that suite of cases we've had over the past 5 years. It's also well known that the substantive law of the agreement and the law of the arbitration clause can be different, but it's generally reasonable to assume, I think, that parties intend or expect their contract to be governed by a single system of law. If they didn't intend that, then you think they'd expressly say so. There are good reasons why an agreement on the choice of law to govern a contract should generally be construed as applying to the arbitration agreement, because it provides certainty, it provides consistency, it ensures coherence, that evil of inconsistent decisions by tribunals or judges, and let's be honest about it, it avoids complexity and artificiality. And I do think there is a bit of a trend at the moment of trying to game these questions between arbitral parties in order to obtain a procedural advantage. So in principle, I think the law governing the parties' arbitration agreement may govern at least some issues of joinder. And in every case, I think the proper approach is to decide what system of law should be applied to the issue. And that can be broken down into 3 stages. I think first you've got to characterize the relevant issue. Then you need to select the rule of conflict of laws which lays down a connecting factor for that issue. And then finally, identify the system of law which is tied by that connecting factor to that issue. So I'll give you an example. If the question is, who are the parties to the agreement to arbitrate, then the law of the agreement to arbitrate will govern. But if the question involves other issues, like whether a party is an agent of another party, or whether a party is an alter ego, or whether a merger under foreign law entitled or obliged a party to arbitrate, then other laws might apply. I mean, just imagine in the alter ego example, that may well involve looking at the law of the place where the companies were incorporated. Well, I had a look to see whether the model law helped on this, and in short, it doesn't. And so it's tempting just to move on and say, Peter, that's the answer. The model, but I'll expand it a little. It provides that the arbitration agreement should be recognised and enforced in accordance with the parties' intentions. So that suggests joinder ought to be possible as an element of the parties' agreement to arbitrate, but not otherwise. And Marion asked the question earlier whether we were seeing clauses in contracts which provided for joinder, and in my experience the answer is no. I haven't seen that. We get boilerplate clauses for arbitration which are truly awful. I mean, they often don't specify anything at all except that the parties are going to arbitrate, sometimes in accordance with the rules of an institution that doesn't actually exist. I have one of those at the moment, purporting to arbitrate in a particular institution in Cairo, which has never existed, but which is broadly the same as the name of a Cairo institution. So I had a look to see whether there was anything in the Arbitration Act, and there's not much there either. Section 35 says that the parties are free to agree on consolidation. Well, thanks very much. We may we? So the parties are free to agree in consolidation with other arbitral proceedings, or there's a power that concurrent hearings can be held, but unless the parties agree to confer such power on the tribunal has no power, says the Act, to order consolidation of proceedings or concurrent hearings. That's deeply unhelpful, really. So what's the takeaway on this issue? Well, for me, first of all, party consent, whether express or implied. Implied. So consent to joinder is the easiest way to streamline multiple disputes. But in the absence of consent, look at why joinder is requested, because that might determine the choice of law which will apply to the application. And then finally, at first blush, I think it's not a bad start to have in mind or to think that the law of the seat will be the applicable law to determine whether joinder is allowed or appropriate.
Robert, thank you. The lawyer's answer of "it depends," which is as ever helpful, but that's why we do what we do. Let's assume we've got the power to join. The next stage of the analysis must be what are the factors that we should have in mind in exercising that discretion. Is it some things ruling things out, like different seats or different laws, arbitration agreements? But what else should we have in mind in deciding whether to exercise this lovely power that we've got, Marion? How should we deal with it?
I'm not going to give the answer, it depends. Tempted though I was, but that fence I shall firmly not sit on. I think you're guided by the basic principles, aren't you? What will be fair and what will be efficient. And you simply keep on cross-checking every factor against that. And it's not one factor. It's not one ring that binds us all. I think it's multifactorial, has to be. And I think everyone on this could write down on the back of an envelope what they immediately want to check. The sort of factors that you would take into account are common sense. So you're going to look at the parties. To what extent are they the same parties or same-ish? There's a different approach about that. Same agreement, same arbitration agreement, common questions, overlapping questions of law and fact, common governing laws. You're going to look at that wonderful concept of the same economic transaction. To what extent can you bring all of the parties into the same transaction? You're going to look at the extent to which you're going to be juggling different institutional rules. I mean, one of the things I found, Peter, of great interest, I really hadn't taken it on board, is this debate that's opening up between the institutions, where they will establish a protocol to enable consolidation between arbitrations going on, say, for example, between the ICC, one in the ICC and one in the SIAC, a form of a protocol to allow those to be consolidated. That's how sophisticated the institutions are becoming about this. Ultimately, you're going to look at the effect of the cost. Everyone will tell you it'll save money if it's to their advantage to say that, but you'll need to break it down. Does it? actually do that? Does it mean that there's a party who was faced with a really very simple, very straightforward, streamlined process to the final decision, now being faced with a much bigger, burdensome project in order to get the award? The risk of conflicting awards, again, you're going to break that down. Is there really that risk there? Common themes, the timing of it, the stage at which it's being done. It's easier to do it at the beginning than it is as the progress moves on. Conflicts of interests, the impact on both parties, the impacts of saying yes, the impact of saying no. All of those factors will come together. So it's not it depends, it's what achieves fairness and efficiency. And can I just say, we're getting some interesting comments about contractual provisions. It's telling, like lawyers always do, on one hand, someone is saying, definitely seeing more involved, more contracts involving dispute resolution procedures, allowing for consolidation. And somebody else saying the opposite, that whereas bespoke joinder and consolidation provisions were there 10 years ago, as the institutional rules have become sophisticated and started to talk about it, that's the way they're providing for these bespoke provisions by incorporating the institutional rules. It's interesting.
So that was it depends, wasn't it then, Mary?
Yeah, of course it wasn't. Basic principles, back to basics.
Yeah, good. We've already heard that there's a lot about consent and consent in the appointment of the tribunal. And the French case, which is convenient, we've got a French professor on board, of Siemens.co, really did change actually all the institutional rules pretty much about how in those circumstances the tribunal is to be appointed. Denis, could you give us a quick whistle-stop tour through Siemens.co and what it decided and the institutional consequence of that?
Yes, sure. So the .co case was not about a joinder or a consolidation, but about a multi-party arbitration, which had begun as such. Since the beginning, there were three parties. There were one claimant, I guess, and two defendants. And according to its rules, the ICC had the claimant appoint one arbitrator and the defendant together appoint one arbitrator. But the defendants protested, saying that they were given an unequal opportunity to play a role in the constitution of the tribunal. The award was challenged, and the Court of Cassation say that the award had to be voided because the principle of equality between the parties during the constitution of the arbitral tribunal had been breached. So it is important to understand it does not mean that the parties must play a role. Rules, for instance, rules saying that all arbitrators must be appointed by the center would not pose any problem. The principles say that the parties must play the same role. So it can be no role at all, but they have to play the same role in the constitution of the tribunal. So if you have one party who can choose an arbitrator, but two parties who have to decide together, it's unequal. Now, of course, there is an important caveat which appeared in the judgment of the Court of Cassation in 1992. Sorry, I did not give you the year, so it's an old judgment. But the Court of Cassation observed that, of course, if the parties do not protest when the arbitral tribunal is constituted, they cannot use this argument later during enforcement or proceedings for the setting aside of the award. And of course, this is consistent with the estoppel principle I reminded earlier. So now, if you apply this equality principle to joinders and consolidations, we see there is an obvious problem. Because if a third party intervenes in an arbitration, it means the third party did not play any role in the constitution of the tribunal. if this third party is joined. We have the same problem. If you consolidate two arbitrations, now, if the two arbitrations are between the same parties, there should not be any problem, because both arbitral tribunals have been constituted by the same parties. So whatever the tribunal you choose for entertaining the consolidated disputes, the arbitrators have been chosen by the parties in the same way, so there should be no problem. But if you consolidate two arbitrations with different parties, it means that during one of the arbitral tribunals, you will have some parties or a party who will be able to say, I did not play any role in the constitution of this tribunal. So how do you address this? Well, arbitration rules, of course, have addressed this issue, especially the rules, no, maybe not all arbitration rules, but at least the ICC rules. So we can evoke the ICC rules, but first I would like to evoke the Swiss rules for those who do not know why. It's because those rules are the rules of the moot problem. So in Article 4 of the Swiss rules, it is provided that a starting arbitration can be consolidated with a pending arbitration between the same parties. So since it is between the same parties, I guess there would not be any problem, because those parties would have chosen the arbitral tribunal which is already established. Now, if we think about the joinder of a third party, if you look at the provision, there is no real solution. So if you have an extensive interpretation of the provisions about the appointment of arbitrators, you may try to argue that the court, the arbitration center, could, in such an instance, maybe replace all the arbitrators so that it would appoint all the arbitrators, and it would be according to, in accordance with the equality principle. Of course, there would be a problem only, I think, if the arbitral tribunal is seated in France or in a country which recognizes this principle, or if the award will, is likely to be enforced in France or such a country. If we talk about the ICC rules, they are much more sophisticated, especially if you take into account the latest version of 2021. So ICC rules, Article 7 provides for interventions and joinders, and Article 10 for consolidations. So the first principle is that the intervention or the joinder of a third party is not possible if any arbitrator has already been appointed. So it solves the problem, because it means that they will all take part in the constitution of the tribunal. But there are two exceptions to this. If all the parties agree to the joinder or the intervention, then it is possible, even if an arbitrator has already been appointed, but it means that all the parties waive the right to object. Or if the arbitral tribunal is already established, then the arbitral tribunal can decide on the joinder. But, so this is an addition of 2021. But the third party must accept the constitution of the tribunal, which also solves any issue, I guess. Now, if you think about if we talk about consolidation of pending arbitrations, it's possible under Article 10. And since 2021, so according to the new rules, so no, but I'm not sure there is a change here. So what are the conditions for consolidation? The parties have agreed to it, or all the claims are based on the same agreements, or the claims are based on different agreements, but the parties are the same. So if the parties have agreed to the consolidation, I think there is no problem. if the parties are the same, I think there is no problem. Now, if the claims are based on the same agreement or the same arbitration agreement or agreements, the parties may be different, and then we may have a problem. But I think that if one of the party raises this issue, and if the arbitral tribunal is seated in a country acknowledging this equality principle, then I think that the court could refuse the consolidation according to Article 10 itself, because the court has a discretionary power to decide whether to consolidate, and it has to take into consideration whether one or more arbitrators have been confirmed or appointed. So I think it is one of the situations in which the consolidation could be refused. I think could be one of the parties objecting to it because of the equality principle. One last observation: it's not only it would not only apply in case of consolidations or joinders, but it may also apply in multi-party arbitrations. There is a paragraph 7 now, since January 2021. There is a paragraph 7 in Article 11 of the rules. No, sorry, it's Article 13, and the new paragraph is 6, sorry, so paragraph 6 of Article 13. It's a general provision according to which the court, the ICC, no, sorry, yeah, it's paragraph 9 of Article 12. I'm really sorry. So this new provision says that in any event, the court can decide to appoint all arbitrators if there is a risk of unequal treatment and unfairness that may affect the validity of the award. So I think that even before this addition, according to the other paragraph of this Article 12, the court could do something like that. But now it's very clear, and I understand this addition to have been made to address any issue related to fairness and equality between the parties.
Denis, thank you very much. There was a question in the chat about the joined party appointing an arbitrator and having a 4-person panel. Of course, that won't work because we need an odd number to make sure that we don't get deadlock. So I don't think that's going to work. Generally, it will be all out and the institution appoint, or get it in before the tribunal are appointed. Yeah.
If you have an even number of arbitrators, then there is the risk of deadlock. That's right. But under some legislations, it would not be unlawful. For instance, the French Code of Civil Procedure does not provide for an odd number of arbitrators in international arbitrations. So it may not be contrary to the law of the seat. It may be contrary to the arbitration rules. But of course, as you say, Peter, there would be the problem of deadlock. There could be.
So not unlawful, just silly.
Yeah.
Anyhow, but whatever we do with our joinder, there is going to be issues about confidentiality. Robert, could you give us a quick sketch on confidentiality issues in joinder?
Yes, I mean, everybody knows arbitration. We had apple pie and motherhood at the beginning. Arbitration and confidentiality, they go hand in glove too. But there have always been exceptions. It's not an immutable rule, actually. Much to the surprise of some parties, I think. Confidentiality falls away when it's necessary for the establishment or protection of a party's legal rights. For instance, an application to the court under the Arbitration Act in the UK, an application in a foreign jurisdiction for injunctive relief, all of those sorts of things. So there have always been exceptions. So is confidentiality a big thing? Well, it depends. If a party's joined to arbitral proceedings, then they become subject to an obligation of confidentiality too. And a party accepts that in agreeing an arbitration clause which permits joinder, I think they also agree that a new party might join the arbitration and have sight of documents and submissions already submitted by the parties in the reference. And let's face it, it's a pretty limited breach of confidentiality. And look, I know a breach is a breach is a breach, but and either it's permitted or it's not. But it can be permitted either by express agreement, or of course our friend the implied agreement, or with one of the exceptions that are well established, and I've just dealt with a few of those. Or I think in this case, it's just a principled and legitimate extension to the exceptions relating to confidentiality. So I think it is a breach of the confidentiality agreement, but I think it's perfectly acceptable either as an extension to already well-known exceptions or as a part and parcel of the provision by which joinder is allowed in the first place. Is that quick enough for you, or do you want me to? I could go on longer if you want me to.
No, that's fine, Robert. That's fine. We have half an hour now to do remote hearings, and so we'll have to take that at a fair canter too. But before we do, I just wanted to pay tribute to some excellent work by Icc and a few editors, including James Hosking, who at least was on the call earlier. James, if you're listening, thank you so much for the excellent work that you have edited with your co-editors. There are 20-something, 22 or something country reports on the position on a right or otherwise to an in-person hearing and remote hearings. They're available on the Icc website. There's quite a few different Iccas, but it's arbitration-icc.org is the one you want. They're all there, and that they are a phenomenal place of learning, and I commend them to you unreservedly. With that glowing praise for the work of James and others, let's turn to this. So Nigel, can I come to you first, and your experience of fully impartial virtual hearings? I know you had a decision well before the pandemic on video conferencing and witnesses joining by video, but what was your experience also of hearings during the pandemic?
Well, my overall impression of virtual hearings during the pandemic is one of astonishment. I was surprised that the technological facilities were there all along and none of us knew it. I was also surprised that tribunals and parties adapted so quickly to the need for remote hearings. In the very first week of lockdown number 1 last March, I found myself sitting at home, hearing an action in which, of course, counsel and solicitors were at home, and evidence was given from Kazakhstan, Belgium, and the United States. And it all worked as smoothly as if we'd been conducting such hearings for years. It was really very surprising indeed. But having said that, it is perhaps not all plain sailing. Concentrating upon a screen, listening carefully to what is said, is, at any rate in my experience, far more tiring than listening to oral submissions in person. As a result, more frequent breaks tend to be required. Electronic documents, well, they are very impressive. The manner in which they are presented is usually good and enables them to be found quickly. But having more than one document open at a time is difficult in the absence of a facility with split screens or the presence of multiple screens. And even if the tribunal has such facilities, it is expecting a lot of the tribunal, both to listen carefully to what is said and at the same time navigate its way through the electronic documents. And of course, the other consequence, which is of particular relevance in the context of international arbitration is that with different time zones, some of the participants may have to sit unusual hours. Some may find themselves having to sit very early in the morning and others very late in the day. But overall, my experience of remote hearings has been really a revelation as to what is in fact possible.
Thank you, Sir Nigel. Marion, could you help us? What is a hearing in this context? What are its distinguishing features that distinguish a hearing, whether it's in person or remote?
Avoiding the desire to become hugely philosophical about this, because I've actually spent more time thinking about this question than I did about joinder and consolidation. And I'm glad you asked it, because you just take it for granted. We're going to have a hearing. And I decided that I could sum it all up, and it's trite, but I think it's right. It's a hearing. That's what it is. You simply want to be heard. Whether you are claiming or defending, it is the opportunity to tell your story and be heard. And so it's going to involve the full story. It carries with it the notion of putting the evidence, making the arguments, looking your panel in the eye. These are the people who are going to decide, and explaining. And that is literally all it is. And once you put it like that, you obviously have to add the word fair. There has to be a fair hearing. How you get there is open to huge debate and discussion. I think the idea that virtual, physical, ultimately, I think you can do it in both. I just want to put a plea in to remember the client, because I think it's quite easy for us as lawyers and as arbitrators, as the resolver, to focus on the magnificent way we are getting these things up and running and heard. Is it the same experience for those who are now little black boxes, not really participating? I think we just need to think that through. The way we put the client on mute video, mute microphone, doesn't quite put them in the same way into that physical hearing room that they used to be. Maybe if that doesn't add anything to it, maybe that was just the opportunity to share the same ghastly cup of coffee. But maybe there was also an opportunity to be heard in a different way that we're not yet addressing. So, philosophical question, obviously proving I would never get a philosophy degree, but lots to think about, I hope.
Well, having a client unseen and unheard is manna from heaven. They're only going to give evidence and ruin a perfectly good case. Is my view. Robert, can we come back to consent? Consent, if the parties consent to do something virtually or remotely, or to the contrary, agree they're not going to do that, and they want an in-person hearing, how does the tribunal reconcile that with its mandate to make a prompt decision without delay type decision? And if one party's for and one party's against, what are the considerations the tribunal are going to have in mind?
Well, let me first say that I agree with everything Marion said. I think this concept of fairness is not trite. Actually, it's essential to everything that we do and that the parties expect, and it shouldn't be glossed over. And I think the point that Marion makes about the client's experience is quite important too. Although, in my experience, having done quite a few remote hearings now, I tend to have another screen with a feed. Either with the rest of my legal team or with the client. Hopefully I have the filter of the legal team between me and the client. I did have one the other week in the Court of Appeal, just being anecdotal for a second, where the Court of Appeal said to me that they were having trouble hearing me because the link was breaking up every so often. And I got a note on my separate screen from my junior which said, "Don't worry, they haven't missed anything important," which which I felt a little bit sad about. But anyway, so look, if the parties agree, there's usually no problem, because usually the tribunal will follow the parties' agreement. And so the issue really arises if the parties are not agreed, and then the question arises, well, what then? And I think the starting point is probably the terms of the arbitration agreement. Does it permit a remote hearing? And if you can't find the answer in the arbitration agreement, then do the institutional rules help you? Do they permit a remote hearing, or indeed forbid them? And if not, let's go back to basics. What's really needed is a process which allows both parties to be heard and both parties to be treated equally. And of course, all subject to that architectonic obligation to conduct hearings in an efficient and expeditious manner. And my view is that in the absence of a specific mandatory provisions that hearings should be in person, I really wouldn't be sympathetic to an argument that a hearing has to be in person. After all, if national courts consider that remote hearings preserve the administration of justice, then why should arbitration be any different? And let's not forget, hearings involving the giving of evidence and cross-examination and submissions by video are not an invention of this pandemic at all. They've been around as a convenient method of hearing evidence in international arbitration, and indeed, unbeknownst to all of us, in court as well, for years. What about concerns over cybersecurity? Well, maybe there's a reason not to go with what the parties want, because arbitration, of course, is this secretive, confidential world, as opposed to the open justice of the courts. So I think the power to hear evidence remotely will be fundamentally a question of law or of the institutional rules. If the tribunal has power, it must determine the relevant test and exercise the power. As it happens, the ICC has a model protocol which tribunals are invited to discuss with the parties, and a set of model directions for conducting hearings remotely. And those model directions include questions about cybersecurity, data rooms, secure links, and so on. And what I try and do is put the onus on the parties to consider those questions and do the best they can to sort those out themselves. But I think there are some interesting questions that arise. What's the burden of proof in an application for a hearing, for a remote hearing? If I'm sitting as the tribunal, do I have to decide whether one party has to show why a remote hearing is needed? Or does the party resisting an application for a remote hearing have to establish why it would be inappropriate? Well, in my view, a decision to hold a hearing remotely would be difficult to challenge as long as arrangements are in place which ensure those provisions which Marion set out in summary, that a party knows the case against it, that they have an opportunity to present their case and respond to the case against them, that the parties are heard by an impartial and independent tribunal, and that the parties are treated with equality. And equality doesn't mean absolutely treating everybody in exactly the same way. Don't need a chess clock provision. It just means giving everybody the same chance to be heard and to have their case considered. And it's not terribly difficult to put in place mechanisms, directions, and orders to ensure that happens. And really, I see that as due process or natural justice. So I think tribunals are going to have to decide and consider why one party says a remote hearing would be hard or unfair. And there are local circumstances which might make it unfair to hold a remote hearing. I've got a party in sub-Saharan Africa at the moment where it's vanishingly difficult to get an internet connection. And so holding a remote hearing with the parties there might well result in unfairness. And I suppose it's not an all or nothing decision either, because it might be possible to have a hybrid hearing where, for instance, submissions to the tribunal by the lawyers are heard by video link, but evidence is heard live in some convenient or less inconvenient venue. You do need to address technical difficulties, and I think there are timing and cost consequences as well. For some parties, the cost of providing the necessary equipment to provide an adequate remote hearing facility can be considerable. And I think so long as everybody has in mind all of those issues and they're addressed and everybody has a chance to be heard about those issues, it's then up to the tribunal to decide what's right and proper, what's fair, to do justice between the parties and to hear them.
Thank you, Robert. Yeah, it must be a strange concept to think that Sir Nigel would be hearing a challenge to an arbitration award and hearing that challenge remotely if the challenge itself was based on the fact that they had had a remote hearing. I mean, it would be ironic, to say the least. But Denis, can I come to you on the due process matters that Robert touched on? If they're able to present their case fully and reasonably, is that sufficient to dictate a remote hearing is okay, or are there other considerations?
Well, it depends, but I won't stop at that, don't worry. I think that, no, I was joking, but it's a bit true. I think that you cannot say that because a hearing is held remotely, due process principles are necessarily violated or are not violated. I really think it depends on the circumstances. Of course, if a party has huge difficulties in having a good internet connection, you may have a breach of the equality between the parties during the arbitral proceedings. But you can argue, on the other hand, that traveling far away for some parties is very difficult. The time difference, you evoked your recent experience, Peter, but the time difference can also create inequality. If you are pleading at a time which is for you the morning and the other party is pleading during the middle of the night, of course there is inequality. So what I think is that it's not, you would have to really demonstrate that under very specific circumstances there has been a breach of the due process principles, of the principle, the contradictory principle, or something, or the equality between the parties, to have an award voided because the hearing was held remotely. Really. Now, there is sometimes concerns about cybersecurity, but I think those concerns are really irrelevant. Because if there is a problem about confidentiality and security of remote hearings, then the military governments, diplomats should not use electronic communication. So, you know, it's always the same problem. An excessive caution will prevent, will stop all progress. If we are afraid of accidents, we should never take planes or drive or so. I think this is not really a serious argument. The real issue is about due process, as you say. Now, I am sure, so as you understand, it depends. So I'm not sure of a lot of things, but there are two things about which I am certain. The first thing is that if you have an in-person, partially in-person hearing, there would be a problem. What I mean is, imagine you have in the same room one of the parties, his or her counsel, its counsel, and the arbitrators, and the other party and their counsel in a remote place, connecting through video conference. Then there would be a strong inequality, and I really think that would be a problem. And second, in my experience, as arbitrator, but also as counsel, in-person hearings are much more pleasant, really. I find, as Sir Nigel, that remote hearings are extremely tiring, especially when it is in a foreign language. I think it's easier to discuss in a foreign language in person. When you are in the same room, you have the impression that you get some feeling about the reaction of witnesses, of arbitrators, of counsels. Those impressions may be false. That's true. But we as humane beings, I think we like feeling that. And I have always, maybe it's because I'm a bit young, but I've always been excited by in-person hearings, arbitral hearings. I've always found them exciting as a counsel, as an arbitrator. It has never been a chore for me. Now remote hearings are very unpleasant. So, and to finish, because Peter said that I may give you some information about France, well, and about state courts, because about arbitration, I think under French law, there would not be any problem about remote hearings. Now, if we talk about state courts, well, since 2017, French courts can organize remote hearings in civil matters if the parties so agree. And during the state of emergency due to the pandemic, those hearings can be imposed on the parties, but this should stop in June. So normally the consent of the parties is necessary. In criminal matters, courts now can impose remote hearings except for very serious crime when there is a jury. And we have something which has been in force since a few years. It is remote hearings for foreigners about to be expelled. So in French airports, you can have remote hearings with a judge in a place of justice, and the foreigner almost at the wheels of the plane, you know. And what I can tell you is that French lawyers, French attorneys, have always been extremely opposed to all those remote hearings, be it in civil or criminal matters, especially in criminal matters, especially for foreigners and the deportation of foreigners. So there is a strong resistance of the French bar, but I think a lot of judges quietly like those remote hearings because they save time. We find they save time.
Denis, thank you very much. We've had a question in the chat about if one of the parties has to appear at very unsociable hours. I think we've all touched on this to a degree, and before we started, I gave an example to the panel of my experience. I managed to get away, which is a unique experience for anyhow. So I was on the far coast of Canada, and I was arbitrator, and the parties and the counsel were in Central Europe on the one hand and Uzbekistan on the other. And there's a 13-hour time difference between me in West Canada and Uzbekistan. So what should have been a one-day case, we split into 2 half days. I sat from 6 a.m. to 9 a.m. The Uzbeks, I think, was 7 p.m. to 10 p.m. And the Europeans were about 3 from memory in the afternoon. So they had the best of it. But it worked very well, and everyone had their say, and we had a hearing. I'm not sure everyone was entirely happy with the result, but that's inevitable. Somebody has to win and somebody has to lose. We've got a few minutes left, and what I was going to do, if I may, is ask each of the panel in a minute or so for their assessment of where we stand on remote hearings. Is it a second best? Is it something that is here to stay? Will it become the normal? Is it more efficient? And ought it to stay? Does it save the planet? Does it save all sorts of time and money for clients, which is, let's not forget them, as we're reminded by Marion. They're not just someone who pays the bills, hopefully. And what the future? So Nigel, would you like to kick us off?
Thank you. Well, I think that post-pandemic, we will seek to take the best from both systems. And I'm sure the courts will be looking into this, and no doubt the arbitration community also. I think for procedural pre-trial hearings, the saving in time and travel costs can't be ignored. And the electronic assembly of documents is more efficient than bundles and will continue. And of course, in international arbitration, this is already commonplace. But what of trials or hearings on the merits? There's often pressure for those trials which involve oral evidence for them to be conducted in the conventional manner. Personally, I'm not convinced that fairness requires observation of the demeanour of a witness. That is overrated, especially in commercial disputes where the contemporaneous documents generally tell the story. And in any event, what one can tell from the demeanour of a witness is often subjective and often unreliable. Witnesses are disbelieved, not because they look shifty in the witness box, but because their evidence does not sit comfortably with the contemporaneous documents. Witnesses have given evidence by remote video link for some time, even in cases where fraud is alleged, and that facility will, I think, be used more in the future. But nevertheless, I think that trials or merits hearings will in the main return to being conducted in the conventional manner. I say that because whilst witnesses can give evidence remotely, some will prefer to give evidence in person to the tribunal. Parties often want their day in court to explain matters, as Marion said, to the tribunal. I'm not sure they would value a day on Zoom as much as they would value a day in court. So I think many merits hearings will return to the normal. So as I said, I think we'll take the best from both systems.
Thank you. Well, that will be music to the ears of the IDRC and the International Arbitration Centre in London. So buy your shares in them now. Marion, your perspective.
I think we're going to enter a very interesting transition period. I think that remote hearings will remain an option. We are going to explore hybrid processes, and I share Denis' concerns about hybrid processes. We're going to have to learn how to manage those. In this process, in this transition period, we're going to learn the lessons of the remote hearings. There are concerns being expressed in the chat box about whether or not witnesses were being tampered with, experts were being got at during the process. Well, we'll start to hear the stories of those, and we'll take those lessons. I think we're going to find that finance directors, CEOs, COOs around the world like virtual hearings when they look at the bottom line. They are undoubtedly cheaper, not in the direct, necessarily just in the direct cost, but also in the investment of time. It's been easier for them to manage it. I also think that where we go is going to be dictated in part by the changes that will come in the virtual offering. We have seen Zoom improve. All of these platforms have improved dramatically in this year. That will continue, and they will move us closer and closer towards the in-person hearing. I'm being told, I said this last year, I'm still being told we're going to reach the stage where we can have witnesses by hologram beamed in to a hearing room in London, which is a new twist on an old story. Beam me up, Scotty. Nothing else to say.
Thank you. Denis, give us your perspective.
Well, I tend to agree with Sir Nigel and Marion. I think the situation will evolve. We will come back to in-person hearings, at least for the important hearings, pleadings, witness examination. And on the other hand, of course, as Sir Nigel said, it would be a good idea to keep remote hearings for secondary issues, for the organization of the proceedings, etc., etc. But more generally, you know, I don't like the current period. I have the feeling that, as I think, as a lot of people, that we are living in a nightmarish science fiction story, you know, and in fact, all those issues make me think of a novel by Isaac Asimov, The Naked Sun, in which you have a planet, Solaria, and on this planet, people are very few. They are outnumbered by robots, but they don't want to meet. They think that it is very, very contrary to social norms to meet. So they avoid each other. Even spouses live in very big houses so that they never meet. And if I remember well, They make children through laboratories. They don't even make love. So I really hope we will come back to meeting in arbitration hearings, in pubs, in restaurants, in meetings, in conferences. I really hope so.
Robert, to be controversial or agreeable?
Well, first let me say that the literary illustration just given by the professor, coupled with him absolutely winning hands down on the bookcase credibility score that we now rate everybody with on Zoom, means that my contribution is going to be a bit lacking. Look, I think online hearings are fantastically convenient in certain circumstances, and I have appeared in different jurisdictions from my desk at home over the past year, and it's been a joy. Even now, wearing pajamas as I am on this, at least on the bottom half for this Zoom hearing, there are some conveniences involved in online hearings, and I think there's an easy split between judge-directed advocacy, where you've got two advocates and a tribunal. I think the Zoom hearings are pretty good, assuming everybody's got decent internet connection and so on and so forth. For trials, I think it's obviously right, and I'm relieved to hear that judges don't decide witnesses are untruthful simply on their demeanour. But it is quite hard as an advocate to get to pick up the judicial grimace over video, or the judicial eyebrow, and even to watch the judicial pen over video. And so we're having to learn new skills as advocates in that way. And I think there's a good argument for having narrative advocacy by video, particularly where you've got foreign jurisdictions involved, but trials still in front of a live tribunal. And there are also risks. And we all know about the risk of the Texan lawyer who had his child's video filter stuck on, so he appeared as a cat. And following that, and to remind me, and I now have it in front of me on the other side of the screen, a friend sent me a t-shirt which said, "I am not a cat," is exactly what a cat pretending to be a lawyer would say. And so I think whether it's the lawyers or whether it's the witnesses who are who people are scared of, there are some risks in.
Well, if you haven't seen the one of the Peruvian lawyer, don't Google it.
No.
It'll taint your internet browser history forever. More about which anon if needs be.